Court is now in session. Please be seated.
All right, introductions, please. Mr. Halseal.
Good morning. May it please the court, Timothy Halseal of Young, Conaway, Stargate, and Taylor on behalf of defendants below Appellees, Thompson Center Arms Company, and Smith & Wesson Corporation. With me today is my co-counsel, Anthony Pisciotti of the Florham Park, New Jersey firm Pisciotti, Lawless, and Erdreich. He has been admitted pro hoc vice and will present argument on behalf of the Appellees.
Welcome to the court.
Thank you, Your Honor. Thank you, Your Honor.
Mr. Rhodes.
Good morning. May it please the court. Joseph Rhodes on behalf of appellants. At this time, with the permission of the court, I'd like to introduce two attorneys from the law firm of Klein Inspector, Charles Becker and Ruxanda Leidacker, and they're both admitted to the bars of Pennsylvania and New Jersey. And today, with the court's permission, Ms. Leidacker will be presenting the argument on behalf of appellants.
Thank you, Mr. Rhodes. Welcome to the court, and you may proceed.
Thank you, Your Honor.
May it please the court, Mr. Chief Justice. My name is Andra Leidacker on behalf of plaintiffs Joe and Hilma Pedicone. Plaintiffs have raised in their briefs two issues. Both of these issues we respectfully suggest individually justify a new trial. My argument today will primarily surface the trial court's evidentiary error pertaining to the G2 contender, which was excluded by the trial court on relevance grounds. Plaintiffs have offered this evidence to establish that the original contender contained a hammer block design, a passive safety, for which a safer alternative design was available since the 1940s. This alternative hammer block design had been included in the G2 contender, which was the second generation of that gun. The G2 contender was a visually meaningful representation of the alternative hammer block design, which our expert, Dr. Knox, had talked about at trial. And he acquainted the jury with the theory of this alternative design. But the G2 contender would have been a powerful visual message to the jury as to how this hammer block design would have operated in an actual gun. So it would have been, Dr. Knox would have had the opportunity to describe the two side by side, to present the jury with this visual anchor, this emotional anchor for what we, the plaintiffs, were telling the jury that had been the alternative feasible design in this case.
Ms. Leidacker,
yes, ma'am.
This alternative design has been incorporated in other guns that were manufactured around the same time as the contender gun that was at issue at trial. Is that correct?
Yes, the alternative design, this hammer block design. So just to give you a little bit of background, the alternative design that we're talking about is a rebounding hammer, meaning that once the gun is decocked, the hammer block, instead of falling down, which is what was happening in the original contender, would come back up and protect the firing pin from the hammer, from striking the hammer. So yes, this original design, this 1940s design that should have been incorporated into the original contender had been available since the 1940s and had been incorporated in other guns.
And your expert, in fact, referred to those other guns in his expert report. Is that correct?
He did not refer to other guns. He referred, there was a listing in his expert report to some patents about regarding other guns. But in fact, there was a motion eliminated by the defendants to exclude those patents as well. And the trial judge did exclude those patents on relevance grounds as well, saying that as long as they did not refer to the contender, that they were not relevant at all.
So did the trial court exclude your expert or preclude your expert from testifying about the other guns that use this alternative hammer blocking mechanism that were manufactured around the same time as this contender?
So that, we never proffered that evidence. What happened here was Dr. Knox provided an expert report in September of 2021 to the trial court and to the defendants. In that expert report, he described the theory of this alternative design, the rebounding hammer block. He also described the G2 contender. He did not describe other guns in the same detail that the G2 contender had been described. In his list of documents to which he was referring, he had listing for patents of other guns, but those two had been excluded. So he was not actually. So the trial judge then made a decision in December. The motion limine was filed in December of 2021, and the trial judge excluded both the other patents and also evidence of the G2 contender in March 2022, about 10 days before trial started. So at that point, the plaintiff's understanding of the trial judge's ruling was that they could not talk about any other guns other than the contender, the original contender, and also describe at trial the alternative hammer block design. But of course, simply describing it for the jury in the words of an expert is not as visually powerful as actually having the gun there and having the jury look at the two guns side by side and seeing the actual implications of how this injury might have entirely been avoided.
When you talk about how powerful that evidence is, would you agree that showing an alternate design that was made at the same time as the contender would have been more powerful?
There are many ways in which someone could try this case. But of course, the G2 contender was designed by the defendants. So our theory, so under Delaware law, a plaintiff may establish negligence through evidence that the ordinarily prudent manufacturer would have incorporated an alternative design, which would have substantially lessened the probability of the harm. So we had different options as to how to do this, and the choice that we had made with this expert in his expert report was to present this evidence of the G2 contender, which the defendants themselves had manufactured. And in that G2 contender, they had incorporated this previously available alternative design. That alternative design was available since the 1940s. And the defendants have never disputed the availability of that particular design at the time. Now, the G2 contender has this rebounding, has a number of features. So it has this hammer block that comes back up that protects the firing pin from the hammer. And it was that particular point that the plaintiffs wanted to focus the jury on. When you see the two guns side by side, when Dr. Knox could have manipulated the two guns to show the actual functioning of the two guns for the jury could have had a look at these two guns themselves. But it was, so that would have been a very powerful evidence, emotionally, visually, a visual anchor for the jury to actually understand, rather than having, and what we were left with was the expert talking about the alternative design. So now, this was not just another corporate document. It was not simply more evidence of the same kind. Part of the defendant's argument had been that, look, you had the opportunity to talk about alternative design. Why is this important? Why is it important to look at the gun itself? This was a 2-week trial. There was a lot of testimony. There was a lot of expert testimony. Having a gun manufactured by the defendants that included this exact design that we said should have been alternatively used in the original contender would have been very powerful. Would have been very powerful to say, look, this would have prevented this injury.
Would you say you were more concerned about the who then than the two comparisons? You cared about that they made this particular gun in the alternate design?
That was very important as well. Yes, that was very important. And we also had documents which are included in the appendix, where the defendant's own advertising about this gun also talked about this hammer block and how it was now much easier. This was the G2 contender had this additional protection, and how it was much easier to operate as well. So they themselves saw it as an improvement over the original contender. All of these things could have been surfaced for the jury, and they would have been important pieces of the big puzzle for the jury to consider in order to get a complete perspective on what the truth was about and what the evidence was regarding this gun. And let me just suggest that the trial judge here kept this evidence out on relevance grounds. Whatever may be said, usually, and the Thompson defendants have also made in their briefing a 403 argument. Whatever may be said about the 403 grounds, this gun is relevant in this trial.
I'm glad you mentioned that. Did you raise the 403 objection at trial?
So we were not objecting to it. We were responding to the defendant's objection, and the issue was decided in a motion in limine filed by the defendants, and we responded to that.
I think what you meant was, did they raise a 403 objection?
They did raise a 403
Right.
objection.
Okay.
The original motion in limine raised 3 objections: 401 relevance, 403 that the prejudice outweighs the probative value of the evidence, and a 407 objection, which had to do with subsequent remedial measure. What the trial judge said was that this evidence was not relevant at all.
Can you fairly read the trial judge's ruling, either his pretrial ruling or his post-trial ruling on the motion for a new trial? Although I agree with you, he does say relevant. He refers to, among other things, confusing the jury, which is really a 403 issue. So would it not be fair for this court to really read the trial court's ruling as encompassing both 401 and 403?
Your Honor, you have obviously the opportunity to affirm on any basis of record. But may I suggest that even under a 403 analysis, the complete preclusion of this evidence was not required. The trial judge talked about, and this was a major, the confusion of the jury, and also there is a second argument about cumulative evidence. Both of them were part of the original motion in limine. So let me address both of them both of them. One of the major theme of the motion in limine and of the trial judge's decision was that this was modern technology, and that you cannot prove that a gun that was an old gun that was made in this case in the 1967, that's when it was designed, that an old gun cannot be proved, negligence cannot be proven with respect to a new gun because of advances in modern technology. That's not why we offered it. We did not try to prove that the defendants were negligent because they failed to anticipate developments in modern technology. That was not our point. Our point was simply to have the jury look at a design that was available since the 1940s and compare 2 guns, one of which contained this design, one of which did not contain this design. So the very narrow focus of that, our proffer of evidence was with respect to this hammer block design. Now, if other issues might have been concerning with respect to confusing the jury, those issues could have been dealt with in instructions to the jury, in instructing the jury how the purposes for which they may consider this evidence. But the trial judge instead opted to entirely take this evidence out of the jury's consideration. So,
did you preserve those arguments, those 403 arguments? That is, did you, in response to the motion in limine, did you address the 403 issues?
Yes, they were addressed, and our brief cites where they were addressed. Thank you. May I also, so the other issue that was part of the motion in limine was this idea of subsequent remedial measure. So let me briefly address that as well. Now, what we have here is a hammer block design from the 1940s. The gun The original contender is designed in 1967. Mr. Pedicone's gun was manufactured in 1978. The original contender is designed in 2001. The injury occurs in 2016. Pursuant to Rule 407, in order for something to be barred under the subsequent remedial measure rule, the remedial measure has to have been taken after the injury. None of these things occurred after the injury. The injury occurred in 2016. Everything else preceded that injury. So the Thompson defendants did not redesign this gun in order to respond to Mr. Pedicone's injury. So the rule itself does not apply on that basis alone. Additionally, the rule itself suggests that that the court may admit, even if, let's say, that this had been taken as a subsequent remedial measure, that evidence of a subsequent measure may be admitted to prove the feasibility of precautionary measures. So that itself was also a basis on which this could have been admitted under that rule. One more issue that I would like to address is there are certain issues regarding prejudice in this area, and I understand many of your questions do go to that issue. This G2 contender contained this hammer block design, and Dr. Knox was prepared to show the jury how the two guns operated in a video that we could have presented to the jury. And that in itself would have visually illustrated the mechanisms of these two guns and how the two could have been incorporated into the original contender. So I wanted to make sure that that I convey the emotional value of this additional evidence that should have been admitted, so that the jury could actually see it, could understand how this gun operated. I see my yellow light.
You don't find that to be confusing at all to the jury, having a gun manufactured so much later versus the original contender?
Your Honor, I'm running into my rebuttal, so may I briefly respond, and then I will sit down. The trial judge has a lot of leeway in terms of instructing the jury as to how to consider evidence. So we were going to offer this evidence for a very limited purpose.
Okay. Thank you.
Thank you very much.
Thank you.
May it please the court. Again, I'm Anthony Pisciotti, and I represent the Appellees. Thank you for allowing me to appear before the court and to argue. I think the justices have a very good handle on what's happening here. So just for context, the Contenders is designed in the 1960s. It's a very specialized firearm. It's unique because it has high adjustability. It has a very precise trigger that's adjustable. It has all these features that make it a very precision firearm. So we have the 1960s as the frame of reference. Mr. Pedicone acquires a firearm from the 1970s that then goes through any number of different hands and changes, and then he uses it. And quite frankly, he says the reason he wants the original Contender is because he loves the adjustability and he loves the trigger pull. So he specifically wants this design. But when it comes to timing of these alternative designs, we need to look no further than the jury instruction, but to appellant's own brief at page 12, they quote them, Delaware law permits a plaintiff to introduce evidence of any feasible alternative design available when the product left the manufacturer's control. So here we have 1978. 1978 is the point upon which we fix the alternative designs. And Judge Carpenter was very clear to them, and he said they weren't prevented from marshaling any alternative designs. The only thing he found troubling, and correctly so, was the contender was this highly adjustable dual safety, had a manual safety, had a passive safety, had a very fine trigger pull, precision firearm in the 70s. This G2, and they keep calling it contender G2. It's a G2 because it is completely different. It's not adjustable. Quite frankly, the trigger it's night and day. It's like very adjustable, like a finely tuned Swiss watch, and not to offend anyone, but compared to a 2000s, quartz watch or Apple Watch or any other, they're very, very different. And so the court understood, first the court understood that there's this time frame, which is important. And it also understood the confusion associated with saying in 2001, something completely different was done, and therefore you should have done it in the 70s. And he said, if you have all these alternative designs from the 70s, contemporaneous, bring them. The expert was not limited in any way. The only thing he said was, you can't go tell the jury that because they did something in 2001, and even if it's the same defendant that did it in 2001, that means it was relevant as an alternative design in 1978, because he saw that as one, confusing, because if a jury gets a charge that says you have to determine feasibility when the firearm was manufactured, they understand 1978, okay. But then they hear 2001. I mean, the confusion is high. I mean, it's without. I'm sorry, Your Honor.
No.
Justice, would you like to?
No, that's helpful. I'm curious about your response to what mattered to them was the who, right? That the manufacturer itself was the point that they were trying to make. And I understand what the comparison between the two, but when that matters to them, the who, how do you respond to that?
Of course. So the aspect there is that's really the prejudice, because we submit that there was not an alternative design of a hammer block that would have made this a safer product in 1978. They want to use the who as the alleged, hey, it must be admission of a defect because they changed it. They changed it, as opposed to what they were required to do under the law, which was actually prove that in 1978 their alleged alternative safer design was really that, and quite frankly it wasn't, and that's why they had such trouble. Even though, Mr. Knox, Dr. Knox, and I'd be remiss if I didn't mention this. Dr. Knox passed away, so he can't ever come back, and he can't ever testify again at trial, and he can't do over whatever he did originally. But he was asked, and we cited in our brief, all about alternative designs, and he was on page 22 of our brief, and I don't want to repeat it, but he was asked about, do hammer blocks exist, and how long do they exist? Since World War II. And the plaintiffs chose to present these arguments through simple testimony of Dr. Knox. They weren't prevented from, our experts had PowerPoints, we had explanations, we had analysis, we showed actual engineering of the components and how everything worked. They decided to do it by testimony, and no one can prevent them from presenting their case. But they had almost 2 days of Dr. Knox on the stand trying to explain his alternative theory, and frankly, the jury rejected it. I mean, the case was started out, and this point's going to get to the second point of the argument a little bit. There's a manual safety on this firearm, which the user manipulates to make the gun safe or fire. And then there's the passive safety. So it's got redundancy. So just based upon that alone, the jury could find that there's no defect, which clearly they did. Mr. Pedicone originally testified that, it didn't have a manual safety, or he didn't know it had a manual safety. This is how he started out until one of plaintiff's own witnesses said, no, I told him it had a manual safety. At which point, and he was the last plaintiff witness to testify, on cross-examination, he admitted, yeah, I knew it had a manual safety. So the themes and the theories about which safety was important and what would have prevented this incident and how the incident happened really unfolded in front of the jury. And I think the jury very easily could say, well, just with the manual safety alone, the product's not defective, which I believe they did. And I'm a little remiss because I don't know if I should give you the factual predicate.
Can we just, before you go there,
Yes,
Mr.
Justice.
Pisciotti, during appellant's argument, the contention was made that the trial court also excluded reference to certain patents, and that limited the plaintiff's ability at trial to present these alternative designs that were available in 1978, or they couldn't. Therefore, because the trial court excluded the patents, Dr. Knox couldn't testify about these other guns that were manufactured at the same time that used the alternative hammer block mechanism. Can you respond to that issue?
Sure, that's incorrect. There were no patents that predated the 1978 manufacture of the contender that were excluded that had alternative designs.
What were the
my
patents?
recollection was that these were subsequent Thompson Center patents for designs after this contender was made. But they were not limited in any way with respect to. They talked about Smith & Wesson firearms, and Smith & Wesson is a parent of Thompson Center, and how Smith & Wesson firearms had rebounding hammers and had passive safeties that were different. They talked about them, but they never went beyond that. And again, I don't believe it's our job to tell them how to present their case, but they talked about it. If I was doing it, I might have done it differently. But Judge Carpenter in the motion for new trial very plainly points out they were not prevented from. I'm trying to find the reference, Justice. From offering the alternative designs from any means they wanted. And in fact, Dr. Knox was given wide latitude with respect to what he was allowed to talk about. Frankly, he was allowed to talk about things that had nothing to do with this incident. He was allowed to talk about, you could drop it and it could fire. You could bump it and it could fire. You could manipulate it and slip off the trigger and it could fire. He was allowed to talk about all these things when what we have here is Mr. Pedicone is in a vehicle loading a hunting firearm, a single-shot hunting firearm. Don't have to load it until you go actually to hunt. Outside of a locked gate from a junkyard. And his testimony is, well, I wanted to get ready to hunt. Well, to hunt, he had to leave his vehicle, go through a locked gate, walk through an active salvage yard, then get to a hunting tree stand, climb the tree stand before he could ever hunt. So right there's a lot of questions I'm sure jurors had about why you're loading the gun in the vehicle. Next, he says, well, I didn't know it had manual safety, which we talked about a little earlier. That pretty much was negated by his own admissions. Then he claims, well, then I'm manipulating, I pull the trigger, I move the hammer down, and I slam the gun closed, and then somehow I shoot myself in the leg. The point being, the next part, which is the I slam the gun closed and I shoot myself in the leg, was tested and never replicated. Mr. Knox couldn't make it do it. Our expert said, nope, can't do it. And in fact, we had an expert, a crime scene analyst who's world-renowned, who looked at the evidence. You can look at the cartridge casing. You can tell from the cartridge casing and the tool marks, how did this happen? Was this just a little bit of a firing pin hitting it, or was it the full trigger pull? And lo and behold, he looks at it, he says, nope, full trigger pull. Which again, gets to the, okay, if you're pulling the trigger, then the only thing that's going to stop you from shooting yourself is the manual safety. And the jurors had this whole informed record about that. And they found, which they can, under the jury instruction, that that the manufacturer is not required to design a product that is foolproof or incapable of producing injury. They found that there was no negligent design here in the contender, based upon a full informed record. The only thing they didn't have, and the only thing that plaintiff complains about, is they didn't get to say, 30 years later, someone made it differently, and that someone was Thompson Center, because that is prejudicial. It's hard prejudice to come back from when someone says, well, because I'm sure that the closing argument would be, well, why would they change it? You know, because they're trying to use something that is irrelevant, but done by the manufacturer to confuse the jury, get emotional prejudice, and try to get a verdict on an improper ground. I'm sorry. I believe I'd like to move to then the next. I'm sorry. Before I move on, the other issue here is that if the plaintiffs thought that they needed to introduce the G2, the proper means would have been to proffer this outside of the presence of the jury, allow Judge Carpenter to then consider their proffer, and then actually create the record for this honorable court. None of that was done. We would submit that then is a waiver.
So just to clarify, your contention is that they needed to do that at trial, even though Judge Carpenter had ruled in the motion in limine pre-trial that the G2 design was not relevant?
I believe that would have been the proper method to preserve it.
Why?
How else can this court and one motion in limine is basically an advisory or a preliminary ruling. There are many times that as the case evidence unfolds, the court may say, okay, well, yeah, now I see it a little differently. To present it then allows the record for this honorable court to review it, but you have nothing to review other than the representations of my adversary, some of which are not completely accurate to the record with respect to, the alternatives availability and things of that nature. But there's nothing now. It's just their word as to what their expert would have said about the G2. And again, we can't even go back because their expert is no longer with us, unfortunately.
So in your view, every time a trial judge rules on a motion in limine, in order to preserve that issue for appeal, the party aggrieved by the court's ruling has to re-raise it at trial?
Not every issue, because I think that there are certain issues on motions in limine that are distinct. But I think in a context here where you're trying to suggest that, and I mean, they're trying to say that this is the whole pivotal matter in their case, that even though they claim that they had alternative designs dating back to the 40s, and I think Dr. Knox even said 1898 or something. Did they marshal any of that? No. But if you think the linchpin to your entire case is this one piece of evidence, I think that it would have been probably most appropriate to do it at that point. Yeah. Because how else would a record be made? The other thing too, and I don't want it to be lost upon anyone, is that Judge Carpenter didn't exclude the G2 for any other purposes. He said specifically, well, you might be able to use it on cross-examination. You might be able to use it for other issues, just not affirmatively. But that wasn't done either. So I know I'm going to get close on time. If I might move on just to the second point, Judge Carpenter conducted a very fair, even-handed trial. He did question the witnesses on both sides, plaintiff's expert and defense experts. But his question was simply for points of clarification. I think if we read the testimony of Dr. Knox and the appellant's own brief, by their own admission, Dr. Knox's testimony was confusing. Whether or not that, how or why, don't know. They had manuals from the 60s they were using with different hammers and different manual safeties. Contender, had at first a manual safety that you rotated back and forth. Then Mr. Pedicone's Contender had a manual safety that was a rotating switch that told you what was safe, what was center fire, what was rim fire. They were they were questioning about a different hammer design from an earlier manual when Judge Carpenter asked Dr. Knox, okay, well, where's the manual safety on, and I'm paraphrasing, on this one for purposes of kind of his understanding. And he said, I'm trying to understand this, because admittedly it was confusing because it wasn't the product that was at issue in the case. It wasn't the one that Mr. Pedicone was handling at the time. And so he simply asked that. And he asked our design expert questions and our forensic shooting reconstruction expert questions as well. But it was simply, okay, how do we put this into context? And this was the end of the first day of Dr. Knox's testimony, at which point in time, clearly the court needed clarification. But at the end of that questioning, Delaware Rule of Evidence 614 would have required the plaintiffs to say, well, Judge, we object to the fact that you asked a question of our expert, because the rule says at the next opportunity outside of the presence of the jury. So at the end of that day, they could have said, we take umbrage with you questioning. Never did. Start of the next day, which was another almost full day of Dr. Knox's testimony, they never raised it. They went on to question Dr. Knox, and then he was cross-examined. But the point being, it was simply to clarify the function of a distinct firearm compared to the one at issue. Unlike, and I'm sure we're going to hear about, the Price case, where respectfully the judge was aggressive, cross-examining, antagonistic, incredulous of the witness's testimony, and then struck part of it. So there was compare and contrast. Judge Carpenter making a simple inquiry so he could take a note about the function and how this other firearm works in contrast to the one actually at issue, whereas in Price, there's clearly the judge's sentiment is, I don't believe your testimony, expert, and then went on to exclude part of it. And then lastly, and I know my time is up.
Your time is up. Thank you very much.
Thank you, Chief Justice.
Thank you, Your Honors. I would like to make in rebuttal just very few points. First, let me direct Your Honor to the defendant's motion eliminate to preclude plaintiff's introduction and reference to certain patents. It is on page 9 of the trial court's decision on the motions in limine, and you will see that is where the trial court actually precluded the evidence of the other patents in reference to other weapons other than the contender on the basis of relevance. I don't want to say anything more than that. I just wanted to direct you to that. The two other points that I would like to make is I hear defense counsel to say that what we were asking for the trial judge to admit, the evidence about the G2 contender, is not even an alternative design. And what I want to say about that is that we were not offering the gun itself as a way to prove that back in 1967 you should have designed the weapon, the gun that you later on designed in 2001. That was not our point. That was never our point. What we were trying to establish through these two guns was that one included a hammer block, which once you decocked the gun, fell down and stayed down, and one which, when you decocked the gun, it rebounded back into place to protect the user. So that also brings me to a second point regarding the manual safety versus the passive safety. It is correct that the manual safety is the one that would have prevented firing of the gun either with a trigger pull or without a trigger pull. What is at issue here is the fact that the passive safety is a redundancy. Essentially, it anticipates the existence of the passive safety, anticipates the user not putting on the manual safety. It is supposed to work when the manual safety is not on, because the defendants anticipated that inadvertently a user may leave the manual safety off, and therefore they included this passive safety to protect the user against unintended discharge without a trigger pull. The original contender does not do that, because when this gun is cocked with the action open, then decocked, and you close the gun, the firing pin and the hammer come into contact and it fires, and that's because the passive safety stays down. In the G2 contender, that passive safety, the hammer block, automatically comes back up. So this passive safety is not affected by the user. It automatically works as part of the gun, which means that when you talk about a defect about the passive safety, about the hammer block, the user's actions are not relevant. The negligence in this case was about this passive safety, which is an internal operation of this gun. It either comes up or it doesn't. The user cannot affect that. So that brings me to the...
You're out of time. Thank you very much, counsel, for your arguments. We'll take the matter under advisement.
Please rise.